So, welcome to chapter 18. Finally, we get to statement of financial affairs. By now, you've seen a couple of times the SOFA pop up on the screen, and that's because we tend to, whether it's the bankruptcy lawyers or the trustee, to refer to statement of financial affairs as SOFA for short. So, let's go over the different sections. There's a lot of sections here, and a lot of it really, I like to call it more of a financial history of the debtor. They're just the trustees trying to find out if there's been any transfers of assets, if there's any, transfers could be fraudulent, they could not be fraudulent. It just really depends on the facts. And we'll go over that in a couple of slides. But let's start off with the marital status. Now, I consider this also, because I said financial history, a good way to make sure that there's no mistakes on all the other schedules. So, for example, if you get to the end and when you actually file online with these software programs like Best Case, it'll tell you you did not check marital status, etc. So assuming you made that mistake, you can now realize, wait a minute, my client is married. So let me go ahead and make sure that this was listed correctly on Schedule A, this additional income, and if need be, the means test as well. And remember, two people in a household is going to increase the expenses versus one. So again, it's kind of like a to-do list. You can just check it off and realize there's some mistakes made. Now, if there are prior addresses, make sure to list them. I like to use it as another way to confirm, was there a house sold? Because if there was, how much was received and net proceeds, and where did that money go? If there's $60,000 apparently that was received from selling a home, if it went to another home, fine, they're protected. Well, let me not say they might be protected in their state. I'm thinking of Florida, which has the unlimited homestead exemption. But if it rolled into another house, okay, they're fine. But what if it wasn't? What if they're renting and a year later they're filing for bankruptcy? Where did $60,000 go? Did it go to friends, family? What is going on there? Because obviously that's going to cause some issues. It's also good to list the prior addresses because sometimes clients don't tell you they own a property and maybe they're renting it out or they're living with their parents, for example. And now you see these different addresses and it could perk up your ears to wonder what is going on. Why is there different addresses? Or even if they're separated from their spouse, likewise, that's also going to affect Schedule I and the means test. Now, when it comes to the sources of income, some of the stuff is basic. You just put in there all forms of income, just go by the tax returns. It's not an issue. You got to put the year to date too, because it asks you, for this year. So just look at the last pay stub, try to figure out what, the last pay stub was yesterday. Just look at that and put that as the year to date, and that's it. I will tell you that your trustee is looking for other information, especially when there's a substantial drop in income. That's when they typically tend to ask more questions. For example, I saw a lot of that when we had the mortgage foreclosure crisis, representing a lot of mortgage brokers and realtors. They had this very high income, and all of a sudden, a year later, they're filing for bankruptcy. But of course, and so forth, they would see that big difference in income, and of course, they're going to ask why. The answer is clear. The market collapse, etc. Now, when it comes to this issue, payments made prior to filing for bankruptcy, there's of course certain things that are fine, right? There's no issues with attorney's fees. There's a separate section. We'll talk about that. And of course, we know DSO, domestic support obligations. It is required that that is paid in bankruptcy anyway. So that's not going to affect the case. And of course, we have certain debts that are just more or less in that range of $600, definitely a mortgage. What they're looking to see if other creditors have been paid. This, whether it's an insider or whether it's even a credit card company, maybe a collection action, that's what the court or the trustee is trying to figure out. Have there been payments of more than $600 in the 90 days? Typically, it's not 100%, but sometimes a lawyer say, just stop making payments on your credit cards and 90 days later we file for bankruptcy. I like to say, and we'll see that in another part of SOFA, where lawyers that are probably inexperienced just see the certain number like 90 days and think as long as it's 90 days, we're good. We don't have to worry about anything else. But that's far from correct. Because if you spent $6,000 91 days ago on a credit card, that's going to be an issue. And of course, what was paid for with that credit card? Was it something that was an emergency or you went out on a trip? So it's not just the 90 days. You really have to look at every case one by one separately to figure the stuff out. But you'll hear a lot of times say, well, just, it's been 90 days, they can file bankruptcy. Not really. It's a little more complicated than that, unless it's kind of a clear-cut case where it's really not a big issue as to how much money was spent. Now, when it comes to insiders, this is probably one of the biggest issues with bankruptcy cases. And insiders, as you can see here, the term kind of explains it all, right? We're talking about friends and family, business partners, etc. The problem with insiders is typically I would say bankruptcy season. They say divorce season's in January because most people just try to wait out the year. Maybe they try to get together with these family holidays and maybe things work out and it doesn't. So they end up getting for divorce. I could tell you I never took vacations in January because I knew money would be flowing into the office. And it's more or less that time period too, I would say for the next 3 or 4 months when it comes to bankruptcy. Why? Because of tax refunds. Clients know at the end of the month of January, they're going to get a tax refund. They're going to get X amount. They start making appointments in January just to find out how much it's going to cost to file for bankruptcy. And they typically come in and just pay their attorney's fees in full to get it over with and file. The problem is if the tax refund is large enough, they might end up paying friends and family on some of the debts that they borrowed money from them and they pay them back. And so that's when you have an issue with an insider. When that happens, and we'll go over those issues when we're talking about an adversary proceeding, but there are going to be two choices. Either the debtor pays back that amount to the trustee as part of the bankruptcy estate being settled, those funds go to creditors, or the trustee is just going to sue that individual to recoup the money. Rarely does it get there, but realistically, that's what bankruptcy trustee is looking for. Has anybody been paid back? And if so, then the next step is going to be to recoup those funds. Now, when we're talking about insiders too, we're not only talking about paying back these debts, but also were there any transfers? Now, I put here fraudulent. That's the term that's used all the time, but add the word intent to that. There could be a transfer, but there was no fraudulent intent. So, for example, and I'm going to use this example in a few minutes anyway, but I just had to buy a new car for my wife because her car was totaled through Hurricane Helene. Now, was there a transfer? Yeah, of course, to the title agency. But what if I transferred it to someone else, someone who gave me $1,000? They said the car's in bad shape. I'll give you $1,000 for it, and we're done. Was there fraudulent intent? No, the car was totaled. I didn't feel like paying for it. This individual gave me X amount of money, and that's it. So we do have to look at the intent. So there could be a transfer that's innocent, but again, in bankruptcy terms, we turn to use a term that it's a fraudulent transfer. Sounds horrible, sounds evil, but again, it's just a term. It doesn't really mean that there's intent to deceive the court or the trustee in that type of regard. Now, when it comes to the lawsuits, just basically fill in the blank. Is there any type of lawsuit pending? But again, you can use this as a way to verify what you've done before in the prior schedules. So, for example, if it is by a creditor, was the creditor listed on the bankruptcy petition? Is that debt listed? Is there a lawyer that's involved in that lawsuit? And did that lawyer also get notice of the bankruptcy filing? Also, what if it's not a creditor? What if the client is involved in a lawsuit as a plaintiff? Okay, now we go back to this issue of money. If money is going to come in, is this money protected? We got to know what type of lawsuit. If it's a PI case, every state is different and may not be protected or just a small amount. But then if it's a workers' comp case, we don't have to worry about it. Workers' comp is going to be protected, the funds that are received from that. I've said this before, but I'll say it again. It was a long time ago. We're 18 chapters later. If it's a workers' comp case, I like to make life simple, and that means those funds go into a separate account and keep that separate from any other money that might be coming in that's not exempt. Makes it nice and easy for the trustee, and it means we avoid a lot of issues and a lot of questions. And at the 341 meeting, potentially avoiding an adversary proceeding or even having to sit down for a 2004 examination, which is basically a deposition. So keep that in mind. The lawsuits, again, another way to check if there's anything going on. Now, gifts and contributions, it is allowed under bankruptcy law, but again, make sure if it's listed on Schedule J. I mentioned in the last video for Chapter 17, I mentioned a client that was building up their expenses. Most of the expenses were non-existent, and one was charitable contributions. Let me put it this way to emphasize my sarcasm. Charitable contributions when there were none. There was, well, we pay in cash. There was no ATM withdrawals. And then that's when I had asked, do you have a side hustle that you're getting paid in cash? I need proof that this is going on. So again, if there's going to be a substantial amount, the $5, $10 is just common that a lot of times we put as bankruptcy lawyers, that's fine. Nobody cares about a receipt for $10. But if there's going to be substantial donations, then yes, we better start getting receipts from all this so that there's no issues with the bankruptcy case. Now, when it comes to losses, having just gone through a hurricane, told you I'd go back to this. I am the perfect example. Now, there were no damages to my house. There were damages, like we left the area. We went to a neighbor's house further south to avoid these issues, and the car was totaled. So there's no issues there. But let's pretend for a second it's a house. If it's a house, is that the reason I'm filing for bankruptcy? So suppose that I have to redo it. A lot of times clients take advantage. I'm just going to redo the bathroom now, redo everything. And then they realize they're too much in debt. The insurance proceed didn't cover everything. And now they're filing for bankruptcy. So if that's the case, like always, how much debt did the client get in and how fast did they do so? Because that could be an issue for the bankruptcy trustee. In my car, for the car as an example, I haven't received the money yet, but by the time I already picked up the car. As a matter of fact, I picked up the car 2 days ago. Yeah, so it's been 2 days now that my wife is driving her new car. But once the lien is paid off and everything else, I should have $5,500 in my pocket. Um, if I filed for bankruptcy, immediately the trustee is going to ask, "Well, where's that money?" Now, if I put it towards a new car, chances are I'll be okay. There's no fraudulent transfer there. Obviously, we need another car, so there's not an issue there. We only got rid of it because we had a hurricane. Could this present an issue now? And this is, you see how you have to start tying everything in together and start focusing on so many issues on a bankruptcy case, and that is the exemptions. Are we is there too much equity in the property now? If there is too much equity, then you can see where this is going to be a problem, where now there's equity in the car you might have to pay back. What's the answer to that? Well, it's a car. The more, cars lose their value very quickly. So sometimes just driving around for another 6 months is good enough to bring down close that gap of the equity, and then you're okay. So do keep that in mind. Again, everything ties in together. Now you see something as simple as a hurricane could cause problems for a client. Now, if there's been payments and transfers, again, this goes back to just kind of fill in the blank. How much is the lawyer getting paid? I've said this before, but we'll talk about it again. The attorney compensation, that money goes into the operating account. That is the money of the lawyer. Costs, that's not your money. That is the money that belongs to the court, and the lawyer pays for the credit counseling. So that goes into the trust account. So let's say you get paid $1,500, and let's just say the filing fees and the cost for all this is 500 to keep the math simple. What you do is once the check clears, this $1,000 goes into the operating account. The 500 stays there, and that's how the court costs are paid. So just keep that in mind. Um, Trust accounting is a big issue. It's how most lawyers lose their license. So it's every office is different. In my office, nobody touched my trust account. It was just me, but I was concerned about those risks. Okay. Now, when it comes to closed bank accounts, I put here follow the money. Typically what happens is a client either gets a better offer from another bank, or maybe they're getting sued by that lender. So they just change to another bank. So lender doesn't know, or the creditor doesn't know what the new bank is at. And that's fine. There's no problem there. Any amount, even if it's not exempt, as long as the money goes from account A to account B, there's no problem. The problem is if this account had $3,000, they closed it, and then they open up the account B with $100. Where's the $2,900? Assuming assuming it's not protected or it's not exempt. That would be the issue. But as long as you list it, that's typically fine. Usually clients have the bank statements anyway. If there's an issue, sometimes the trustee will just say at the 341 meeting, they'll continue it, or they'll just approve the bankruptcy pending confirmation of the bank account. So usually they'll tell you, we'll give you X amount of time to go get proof for the bank accounts. Yeah, it's a headache. It costs clients money to get that information. But considering how much they're wiping out in bankruptcy, it's not the end of the world. Now, safe deposit box, I'm going to say the same thing with the safe deposit box as well as storage facilities. This is why I always recommend to go through bank statements to see if there's anything suspicious there. If there is, then you have to ask the client, what is that? Why is this withdrawal being made? For a safe deposit box, the obvious question is, what is in there? Is it, Jason Bourne and there's a bunch of passports and cash in there? You need to know that because it's going to be an issue with the trustee. Likewise, storage facility, what's in there? A lot of times it's nothing, right? It's just, general stuff that the client has is maybe not worth a lot. But I've had clients who have businesses and maybe the business was closed up, but they have nowhere to keep all their stuff. So they put everything in a storage facility. Problem is the business, those, whatever it is, if you're in landscaping, you have all these sit down mowers and everything else, all this costs money. And now we go back to the issue of the bankruptcy estate and what's protected and what's not protected. So you always got to find out what's inside those storage facilities and what's inside any boxes at the bank. Okay. Now this is kind of odd. It's not a situation I've faced before, but you see here that I put an example where, why would someone be holding someone else's money and maybe they're just using an asset as collateral, or you're holding that collateral in case that person doesn't pay you. So it's kind of like the same question when the trustee asks, are you involved in any lawsuits? And the answer is, let's say, typically no. And then you say, does anybody owe you money? Because again, if they do, guess what? The trustee is going to sue that individual to collect, because those are not assets that are part of the bankruptcy estate. Now, here's another one. I'll just put it in here. Environmental issues typically is not going to apply. Sometimes clients freak out. I have gas in my garage. And it's like, you have gas in your driveway from your car. It's not an issue. We're talking about other types of cases. So don't really stress that. That's not going to apply most of the time. Now, as we're getting close to wrapping things up here, business interest. Why? Because again, if there's any money involved here, was any transfer of stocks, it wouldn't be the first time a client closed up shop just to avoid a trustee getting it. So that's why you have to start asking, questions and dig into this. Is there anything fishy going on? Why was so and so all of a sudden added to the corporate documents? These start to become issues where you have to, start asking more and more questions to make sure that the client is being honest with you. Remember, 99% of the clients are honest, but there are plenty that are not. And you have to start asking these questions to figure out why. Okay. Now, there might have been financial statements prepared. So do ask about that. That is something the trustee is going to ask. Trustee is going to look at the tax returns and see that ABC accounting company is the one that prepared the tax returns. And they can just contact that company directly and say, did you complete any financial statements? And guess what? That individual is going to comply with the trustee, because they're not going down without a fight. They have to protect themselves. And so they're not going to lie to a trustee and say, yeah, we prepared documents. This is what we have. So put your client on notice on that. No lying. Lying is just going to reach to more complications in this case and potentially a criminal case, when these cases could be resolved a lot of times easily, either by delaying the case or just filing Chapter 13 and paying back the debt. So keep that in mind with these clients, that, you can always get a feel for a client when they're not being honest with you. Okay. Now, if there is an ongoing business, then again, here's where you see SOFA is acting as a checklist, where now you have to go back and make sure you listed that in the schedules. If you're in a state that has a protection known as tools of the trade, tools of the trade just means and I'll put a link on that in a prior blog post on that. But tools of the trade means, so it's another exemption granted by certain states to protect, business. So I always say my laptop's my business. That's my tools of the trade. Someone else in another type of business, like a landscaper, not only do they have more tools, more expensive tools, right? How much can one laptop cost? but what about all these equipment that landscapers have? That would fall under tools of the trade, and it's just a little more of an exemption. Always confirm if your state has that. Every state, again, is different, and it does provide a little more protection for clients, okay? Now, finally, this is a simple one, probably ignored, but if things go wrong at the 341 meeting, I guarantee you the first person they are blaming is going to be the lawyer. I've even seen situations where paralegals have come to me as form filers, and what did the debtor do? They threw them under the bus. The fact is the debtor did not disclose assets, and now the trustee is chasing the paralegal saying you did this or that. And the paralegal's like, I only did what they told me. I completed the forms. If they lied on it, that's their problem. But these are simple issues that we can avoid. And the simple way of avoiding it is in the old days, we had the printed copy, right? So we would go through each page with the client and say, make sure you initial each and every page. Now with this bankruptcy software, you can convert everything to a PDF, which is exactly the way that it gets filed with the court. But what I would do is to not bring in the client because the client comes in and so much time consuming. It was just easier to email the client that PDF and tell them, here it is, review it. We'll have an appointment in a few days. So, for example, today is Thursday. I will tell the client, review it over the weekend. Come Monday, you and I will talk. We'll do a phone appointment to see what you think if you have any questions. At that point, they marked up all the different areas of the bankruptcy petition that they might have questions on. But they reviewed it, it complied. And so at that point, you tell them, okay, that same email that I sent you this, please write back to me that everything is okay and that it doesn't have to be anything fancy, no legalese, just as long as it states that they reviewed it, then you're okay. All right. So make sure, that is a good thing to do because the trustee will ask at the 341 meeting if it was reviewed. If there's a translator involved, the trustee is going to ask if the documents were translated from English to Spanish. So it is a question a trustee is going to ask. And the way the lawyer can protect himself or herself is very simple. Just saying, well, they initialed each page. Or I got an email saying that everything was okay after we spoke for 20 minutes on the phone going over the different parts of the bankruptcy petition. At that point, the client can scream bloody murder. They can go file a bar complaint if something goes wrong. And what's going to be the response in the bar complaint? The client reviewed everything and everything was approved. At the end of the day, if the client is not disclosing assets or lying, that is not going to fall on you. But the quickest way to resolve that issue, just simply have confirmation. Okay, so we're done with chapter 18. For all these chapters, like I've been saying before, make sure you're also looking not only at the PowerPoints, but at the petition to get a better idea of how this works. Okay. Now, as always, feel free to ask any questions or comments. You can post them on the bottom of this video below, and I'll be more than happy to reply to you. All right. Take care, and I'll see you with the next coming up video.